matter, Captain State of Ohio versus Leon Klotz. We are in the middle of a non-jury trial, still in the state's case in chief. Are there any matters that we need to address before we continue on to the state?
No, Your Honor, thank you.
Mr. Matthews?
I just had a quick question. I hope there are no stupid questions, but do I still make a Rule 29 motion?
Yes.
Okay.
It's treated the same way as a regular trial.
Very good, thank you.
Anything else?
No, Your Honor.
All right, Mr. DePiero, you may continue.
Thank you very much, Your Honor. At this time, the state would call Vincent Cronin. Yes, sir.
You swear affirm the testimony about to give the truth, the whole truth, nothing but the truth.
I do. Thank you.
Okay. Mr. DePiero, whenever you're ready.
Thank you very much, Your Honor. Sir, good morning to you.
Good morning.
Sir, please introduce yourself to the court by saying your name and spelling your name.
My name is Vincent Cronin, C-R-O-N-I-N.
Now, Mr. Cronin, the state has subpoenaed you here to appear in your capacity as a crash reconstructionist, correct?
Yes.
Okay. Please outline for the court what your training and experience background is that qualifies you to be a crash reconstructionist, sir.
I was a police officer for the city of Eastlake for 29 years. I retired in 2017. During that time, in 1999, I had my first accident investigation course and went up through the reconstruction courses. I became a state certified crash reconstructionist in 2004. In 2000, and I believe it was 11, Lake County developed a regional crash reconstruction unit. I was chosen to be the operations commander of that unit. I responded to nearly all the serious injury and fatal crashes within Lake County and investigated those.
What did the Lake County Accident Investigation Unit do?
We reconstructed crashes throughout Lake County. We had mutual aid agreements with nearly every department within Lake County.
As the operations commander, what was your role?
My role was the coordination of a call out, figuring out how many reconstructionists we needed, how many technical investigators we needed, whether we needed evidence technicians, coordinate training amongst the team members.
Okay.
So basically the day-to-day operations of the unit.
Okay. And as a member of the Accident Investigation Unit, did you participate in crash reconstructions yourself?
Yes, I did.
Can you estimate how many?
I've reconstructed just with the crash unit or all together? Considering my time after Intro Tech,
Maybe I should save that question until you're all done.
Okay.
How long were you with the Accident Investigation Unit, sir, as a reconstructionist?
I was there for 6 years.
All right. Now, you said that you were served as a police officer for 29 years.
Yes.
What did you come to do after your service as a police officer?
I began working for Intro Tech Accident Reconstruction and Forensics.
Okay. Now, we've had some testimony already in this trial about what Intro Tech is. So, what is your role at Intro Tech?
I'm a crash reconstructionist.
And what does that mean?
I am the lead investigator for cases that we take in, and I coordinate the efforts for us doing inspections and such, and then I essentially will write a report on our findings.
Okay. How long have you been with Intro Tech, sir?
I've been with Intro Tech for 5 years now.
Have you had ongoing crash reconstruction training?
Yes, I have. Since I became a crash reconstructionist, I've had approximately 700 hours of additional training in specialized fields of crash reconstruction.
Okay, what about instructor training?
I was an instructor at Lakeland Basic Police Academy. I worked for the State of Ohio Attorney General's office, and I worked for Bryan and Stratton College as an instructor for the basic police academy. I instructed several courses, including crash reconstructionist for the new, crash investigation for new cadets. And I currently am affiliated with North Coast Polytechnic Institute, and we still provide training for in-service police officers as far as level 1 accident investigation, level 2 accident investigation, vehicle dynamics, and crash reconstruction.
Okay, sir. Now I'm going to ask you that question about how many reconstructions have you done throughout your life as a crash reconstructionist?
Probably around 500.
Okay. Have you ever testified in a court of law as an expert in the field of traffic crash reconstruction?
Yes, I have.
Okay. Whereabouts and when?
When I was a police officer with Eastlake, I don't know the exact years, I've testified as an expert witness in Willoughby Municipal Court, in Mentor Municipal Court, and in Painesville Municipal Court. Also, as a police officer for Eastlake, I've testified as an expert witness here in Lake County Common Police Court. Since I've been with Introtech, I have testified again here at Lake County Common Police Court as an expert witness in the field of traffic crash reconstruction. I've testified at Stark County Common Police Court, and I've testified at Lorraine County Common Police Court.
Okay. So there's been a significant amount of evidence that's been presented in this case regarding the crash on August 26, 2022. Introtech was retained by the state of Ohio to do a crash reconstruction report regarding the crash involving the defendant here, correct?
Yes,
All right, and you did so, didn't you?
I did, yes.
All right, and you completed a report of your findings and your opinion, correct?
Yes, I did.
Okay. Your Honor, that's going to be State's Exhibit 30. Mr. Culotta, I'm just going to hand you State's Exhibit 30 here. This is your crash reconstruction report, right?
Yes, it is.
Okay. All right, we're going to, as I ask you questions, we're going to refer to that report. I'll ask you to keep it in front of you.
Okay.
Now, as part of your, how did you go about doing your reconstruction report and arriving at your opinions in this case? How did you start?
Basically, we started with looking at the evidence that was presented to us. We got majority of our evidence from the Ohio State Highway Patrol.
Okay, well, let me stop you for a minute, because you review, when you say you reviewed all the evidence that's been given to you, you're talking about the data that you reviewed.
Yes.
And do you list the data that you reviewed in State's Exhibit 30?
Yes, I do.
Okay. Your Honor, I'd ask for permission to have control of the screen, if I may.
Got it.
Okay, sir, I'm just looking at page 2 here of your report, State's Exhibit 30. If you look to your left, you're going to see a monitor.
You can pull that out too if you wanted to a little bit.
Thank you.
What's on your monitor is being projected to the board up on the screen. All right, it's also in your hand, and I'll refer to the page as well. So the data that you reviewed in your crash reconstruction investigation report, it's summarized here on page 2, right?
Yes, it is.
All right, and without reading the entire list here, you have 22 items that include all of the evidence from the, like you said, Ohio State Highway Patrol. Does that include the forensic mapping by Sergeant Fox?
Yes, it does.
Okay, all right. Did you also consider the mechanical inspection report by James Drozdowski?
I did.
Okay, and the ACM, that CDR data from the vehicles?
Yes.
Okay, I'm going to ask you some questions about that later. Weather conditions, sun data, so forth, right?
Yes.
And then we have a couple learned authoritative texts and treatises are listed here towards the bottom as well, right?
Yes.
What did you use those for?
Reference as far as my calculations, and just general reconstruction references.
Now, number 18, the Faro Zone 3D scaled working drawing completed by Introtech. What is that?
So what we did is the data that was obtained by the State Highway Patrol for the forensic mapping.
You're talking about the total station data?
Yes.
Okay.
The total station data. We applied that and took specific areas of that for our investigation, for my investigation in the speed calculations.
Okay, and Faro, is that the program that Introtech uses?
Yes.
Okay.
Faro is a computer software program.
So you input the laser station measurements,
Jim, I'm through now.
you input the laser station, I'm sorry, Joe.
Just wait 1 second.
Okay, sorry.
He's working on that, Your Honor.
Go ahead.
Thanks, Joe. All right, so you use the laser station measurements from the Ohio State Highway Patrol, put them into your own program to make a skilled working drawing. Is that
Yes.
what that means, number 18? Okay.
That's correct.
Now, moving down to methodology, please explain to the court what your methodology is in investigating a crash, and we can talk about the crash phases. I have your diagram up on the screen as well, if that's helpful to you, sir.
Yes.
But go ahead and explain how you move through this in terms of your methodology.
So in the field of crash reconstruction, we have what we call the links in the chain of events. You have 3 areas of the crash. You have the pre-crash, you have the impact phase, and the post-crash phase. Those are your 3 phases. To do a proper reconstruction, you start backwards. You start at final rest of the vehicles, and you work your way backwards to the beginning. And you try and identify as many of the links in the chain of events that you can. Sometimes they exist, sometimes they don't exist, but we try and identify as many as we possibly can.
Okay, now let me stop you for a minute because I didn't tell you this in the beginning. There is a device right here, a little laser pointer.
Okay.
And you see that button right there?
Okay.
You just press that and you can use it.
Okay.
So, feel free to use that to point to items on the screen that are relevant to help you explain. Now, I'm asking you questions about the crash phase. That's something that you consider in every reconstruction, correct?
Correct.
Something that was particularly important in this case because you did speed calculations using this methodology, correct?
I did, yes.
Okay. All right. So the table on page 3 that summarized the methodology that you use in terms of the crash phases, correct?
That is correct, yes.
All right. Now, in investigating this crash, your report indicates on page 4 that you considered evidence from the environment. What does this mean, and why did you do it?
We just basically look at the area of the crash, type of roadway, whether or not there's, in this instance, there's a grassy median, try and get some measurements, and basically, environment is also going to include weather factors.
Okay.
If there's any issues of weather, any issues of sun, maybe sun glare, so we take all of that in consideration.
All right, so before, I'm going to ask you about the sun in a minute. Here, you detail that the area of this crash was on I-90, and you note in your report that we have 2 eastbound lanes and 2 westbound lanes of travel, right?
Correct.
Each of the lanes is about 12 feet wide.
Correct.
Is that right? All right, and now, in terms of the berm, both directions of travel, on the right side, that berm is about 12 feet wide.
Correct.
Okay. And it's a white line, you noticed there, right?
That's a
And what
solid
about-
white line, yes.
Okay, and then on the other side, the left, it's a solid yellow line, correct?
That is correct, yes.
And the distance between the concrete and the grassy median, that yellow line is about 6 feet, is that right?
Correct.
Now, the median itself, you say it's 70 feet wide with a 6-degree downward slope. Please explain what that means.
So, as there's a downward slope from the eastbound lanes and from the westbound lanes, the drainage for the freeway is in the center. All the main drains are in the center of the freeway. So that's about a 6-degree downward slope, and that's designed by engineers for the water to dissipate off a roadway after rain, after snow melts and such. So there's about a 6-degree downward slope, and it's about halfway in the middle.
Okay, so you got a downward for half of it and then upward for half of it.
Correct.
Okay.
And the 60 feet is directly across, straight line?
The 70 feet, yes, Your Honor. It's straight across.
All right, and then the roadway itself, you note, is relatively straight and level in the area of the crash, correct?
Correct.
And you include some photos of the straight and level I-90 lanes on the next page, correct?
Correct.
That's what we're going through. Okay. Now, the conditions were clear and dry at the time of the crash, correct?
Correct.
Did you investigate whether the sun had any role as to the cars involved here?
I did.
And did the sun have any role?
No,
All right, the sun glare was not a causal factor for anybody here, right?
it was not, no.
Okay, now, I asked you some questions earlier about using the Ohio State Highway Patrol laser station data to start your analysis, some of the pictures you looked at as well. And you have in your report where you explain different marks that are seen in some of those photographs. And I want to just take a minute here to ask you to explain what some of these terms are, because you're going to be using them here today, aren't you?
Yes.
All right. Certainly everyone can read, but when we're looking at a yaw mark, a furrow, rut, scuff mark, what are the differences here? What are the main differences? Like a yaw mark, what do we have?
So a yaw mark essentially is caused by a tire that is rolling forward but sliding sideways. It's indicative of having a striation markings on it, which is caused from the tire tread as it's moving along.
Okay. And then furrow.
Furrow is caused in a soft soil type area, grass, sand, dirt, of a sliding tire. The indicative way to find that is you won't see any, the grass, if it's in a grass area or whatever, there'll be furrows, that'll be dug up. You won't see anything.
All right, we have some grassy areas here.
We do have some grassy areas, yes.
All right, I'm going to show you some pictures in a minute. Rut.
A rut is made, it's the same surface, but a rut is made by a rolling tire. So the furrow is made by a tire that's not rotating, or it could be sliding sideways. A rut is made by a rolling tire going through that. And that is indicative of, you would see grass sort of matted down. The grass isn't torn up, but the grass is flattened out. And that would be indicative of a rut.
Scuff marks and skid marks.
So a skid mark is known as a deceleration scuff. And what that is when you apply your brakes, the tire itself heats up the friction of the roadway, from the friction of the roadway, and it develops a mark from the rubber of the tires as it heats up. And then a scuff mark is made by a tire that's both rotating and slipping. And we have a couple of those in here as well.
All right, and then your last definition there, yaw, is that a noun or a verb?
That's a good question.
I mean, it's just a sideways movement of a vehicle in turning, but
Yeah, it's just...
maybe I'll just let you explain it instead of asking you grammar. Go ahead.
Sure, it's when a vehicle is, if you think of a vehicle going straight ahead and now all of a sudden the wheels maybe faced a different way, it's kind of almost synonymous with a yaw mark. That's going to be the mark that is caused. The yaw is the actual movement of the car as it's going through that.
Okay, so the yaw is the movement and the mark is what's left.
Is the resultant factor
yaw.
from the tires.
Okay. All right, and then a demonstration of this, or you include in your report at page 7, let's see if I can, at the top.
Yes.
Please, with those definitions in mind, explain what we're looking at. If you need me to zoom in more, I can do that.
This mark right here, I would consider to be a rut because you can see the grass is laid down. It's matted down. That would almost be from a free rolling tire rolling across there. This
Free rolling, you said.
Yes,
Okay.
the tire is rolling through here. It's not, if the tire was not, it would tear up the grass.
Okay.
Here, this farthest line, you have some areas of rutting, some areas of furrowing. There's some areas where the grass is laid down, and there's other areas where you can see the grass is torn up. That is likely caused from a tire as it's beginning to slide sideways in the grass area. We have this mark right here, which is pretty much a furrow. It seems like it's a rut up to from, sorry, I'm not steady with this. It's a rut from about there to there, that distance, and then it's a furrow the rest of the way. And
All right,
this,
so let me stop you. Well, you just, let me have that pointer for a second. You said, at this line, we're talking about, we're moving from left to right in figure number 6.
Yes,
correct? All right, and I'm going from the middle of the page upwards. You indicate with your pointer that what you see there is indicative of a rut.
yes,
All right, so that is indicative of a rolling tire.
yes.
All right, and then from middle of the page down on that same mark, it is indicative of what?
Of a furrow.
And what is the furrow again?
A furrow is when when there's a locked wheel going across a soft surface. A locked wheel, or it could be in the midst of rotating as well.
Okay, but it's not moving.
It is not a free rolling tire.
Okay, so we had a rolling tire and then not a rolling.
Correct.
All right, go ahead, sir.
And then the farthest mark to the left is a furrow mark all the way from about here down. You don't really see any grass matted down. The grass is pretty much all torn up in that area, so I would consider that to be a furrow.
Okay, and then just, excuse me, moving down to figure number 7, what are we looking at here?
Starting from the right, it appears to be a rut mark. It looks like it's free rolling right at the beginning because the grass is matted down there, and in this last portion of it, it appears to be a furrow. The second mark from the right, that appears to be a rut almost all the way to the end of the road. There's very, very little area right in here where you can actually see grass. The third mark is a rut from the bottom of the page right to about right here. And, I'm sorry, a furrow, and then it's a rut the rest of the way. And then the last mark is a furrow almost the whole way up.
All right, now looking at figure number 7, there's a roadway picture towards the top of that image that's embedded in your report.
Yes, there is.
Which roadway is that?
That's Interstate 90. I believe that is the eastbound lanes.
Okay, that's the eastbound. All right, so here, again, we have a rolling tire and then not a rolling.
Correct.
Are you able to tell from the data that you reviewed what these tire marks are, like how they got there?
They got there from the Dodge Ram as it was sliding across the grassy median.
What caused those impressions in the grass? Part of the dot.
The tires.
Any photos or other data that you reviewed that would indicate that anything other than the tires made marks on that median?
No.
Ask you some questions about yaw marks now. Moving down to page 8, figure number 8. Now, it doesn't look as pronounced on projection, but in your report, and you draw some arrows here, please describe what we're looking at here relative to yaw marks and what it means to your investigation.
For the record here, we're not talking about those rumble strips, right?
Correct.
And Your Honor, may I have page 30 for a second?
Yes.
Top of page 8, figure number 8, handing you the hard copy of the exhibit of page 30, Your Honor.
No.
You see it now? Yeah. It's just a little washed out on the projection screen, but you can see the tire mark.
Yeah.
All right, Mr. Cronin, go ahead.
So,
Stand there, stand there. Is there any way, like a brightness thing on that, or? No, I don't wanna screw around. That's all right, we can play with that another time. All right, good. I've noticed that with other pictures in other cases, so.
Yes, Your Honor.
Go ahead, Mr. Or,
Oh,
Mr. Cummings.
Sure.
okay, thank you.
Go ahead,
Yeah, so this is a yaw mark, and as I indicated before, it's,
If you turn the light off, Stan, over there?
I can try that.
Yeah, that might work.
this yaw mark is kind of, in a curved fashion. And you can see the slight transfer from the rubber of the tires, but you can also see the striations, which would be caused from the tread of the tire. And the tread on the tire is designed to dissipate water and such. So as basically, this is a tire that is rolling forward, but sliding sideways.
On your computer, can you see the mark?
Yes, Your Honor.
Oh, okay, so this has gotta be too bright or
I
something.
think it's just the projector, yeah. On the monitor, you can see the marker.
Yeah,
It's
it's
just-
gotta be
Yes, I
the
can.
projector, the settings on that, we'll have to have Patrick do something. But,
This, figure number 8 is a significant mark in your calculations as it relates to speed, isn't that right?
Yes, it is.
All right, I'll ask you some questions about that soon. Now, you mentioned striations, looking at figure number 9. Yes, Judge.
Just trying to figure out where we are, so, that's the eastbound lane on the right side?
Yes, it is, Your Honor.
Okay. All right, go ahead.
Sure. Now, does figure number 8 correspond to the first laser station recording from the Ohio State Highway Patrol and when they began their measurements? Do you recall? Or?
I believe so, yes.
Okay, all right. Just striations, if you could just indicate with your pointer quickly what you mean by striations in figure number 9.
The striations, the tire would be moving this way, but you could see the striations are at an angle and they're relatively equal. And again, that's caused from the tread wear of the tire. So again, this is a tire that's rolling forward but beginning to slide sideways.
Okay, rolling forward but beginning to go sideways.
Yes.
Okay. All right, now,
Now, those marks are from the, tires on the right side of the vehicle, passenger side?
Yes, Your Honor.
and we're looking at the right meetings, we have a white line and then rumble strips, isn't that right, sir?
That is correct.
Okay. Now, evidence from the vehicle you include in your report, there are some photographs here of the vehicles that were taken at the time that the ACM data was attempted to be downloaded, correct? So we're going to just get through those.
Correct.
We've seen a lot of the cars. Now, I want to ask you about the tires. Did you include at page 11, middle of the page, an area where you're talking about, when you reference a 2008 Dodge, you're talking about the Ram, the truck in the case, right?
Yes, I am.
All right, and you noted that it was equipped with Falcon Wild Peak AT3W tires with a size indicated there, LT 285/70 R17, right?
Yes.
All right, there was a photo that admitted in evidence here of a manufacturing sticker on the truck that shows different tire size.
Correct.
Okay, and you note that here as well, this P265 R17,
Correct.
right? Okay, and then this is what was on the car, the
Correct.
truck, I should say. Okay.
Yes.
All right, what is the difference? What is the difference between what was on this truck and what was rated for the truck?
So the Falcon Wild Peak tires are larger tires. They're also LT indicates it's a light truck tire, whereas the original tire that it came with, a P rating, is a passenger vehicle tire. A light truck tire has heavier sidewall construction, more plies of a construction of the sidewall to help with off-roading type of things.
To do what?
The off-roading, it's for basically for light trucks. It's if you're gonna do off-roading, drive through the woods, that type of stuff. So it's basically makes it more puncture resistant than a passenger side tire.
More puncture resistant? Is that what you
Yes.
said? Okay. All right, Now, that's what LT stands for, light truck, and P
Yes.
stands for passenger. What about this 285 and 265? What are those numbers?
Okay, that's actually the footprint of the tire. That's the width of the tire, and that's in millimeters. So the LT 285, the actual portion of the tire that sits on the road is 285 millimeters, whereas the initial sticker shows that it should be a tire that's only 265 millimeters.
All right, and then, so, you noted this difference, and then you compared the different sizes and determined something about how it would affect the vehicle. What was that?
That the speedometer reading is going to be lower than the actual speed of the vehicle.
Why?
So when you take the totality of everything you have here, the remainder of the tires, so the 70 that you see after the millimeter number, the 70 is what's known as the aspect ratio. What that is the percentage of the footprint of the tire, and it's basically the height of the sidewall. So when you get that 285 or 265 millimeters, you can mathematically turn that into inches, and then you would take 70% of that, and that's going to be the height of your sidewall of your tire. And then the very last number, the 17, that's your rim size. So once you do that, you can actually take your rim size, which is a 17 inches. Once you figure out what the 70% of that is, that's your sidewall height. You add the sidewall height from the bottom and from the top, and that gives you the overall height of the tire.
And what is the difference here?
The 285 70R17 is a taller tire.
How much?
I would have to look at, I don't know. I don't remember offhand exactly how much higher it was.
Was it about 2 inches?
Why is it taller? Man, maybe I didn't follow there.
Because so the second number, the aspect ratio, the 70,
Right.
it's 70% of the 285 is the height of the sidewall. The rim size is the same. The rim size is going to be 17 on both of them. But when you calculate the 285 millimeters, I believe you multiply it by 25.9 to get your actual inches. When you take, if you have a longer footprint, when you take 70%, it's going to be a higher sidewall.
All right, now you noted that doing that calculation, it would raise the center of gravity of this car. Okay, what does that mean, raise the center of gravity?
So every vehicle has its center of gravity, and what the center of gravity is it's a point where, in theory, you can hold that vehicle and it will balance completely balance, the center of gravity. You
So
have...
if you put that truck on a pole, center of gravity, it would just...
balance, it would sit there.
Okay.
So you have longitudinal center of gravity from the side to side of the truck, which is going to be roughly in the middle. You have that's lateral. You have longitudinal, which you take the bed of the truck, the engine's a little heavier. So we know our dimensions from the manufacturer specifications where the center of gravity is. There's also the height of center of gravity, because the center of gravity is going to be to go back to math, an XYZ axis. So the Z-axis is going to be the height of it. By raising the tires up a couple inches, you are raising the center of gravity up slightly, but it is getting raised up.
Okay, and why does that affect the speedometer reading?
That affects the speedometer reading because to figure out how many revolutions the tire makes per mile, again, once you have all these numbers, to get the circumference or the diameter of the tire, you take your rim size, which is a 17, you add your two sidewall heights, you take your height of it, and you multiply that by pi, 3.1415926.8, and then essentially you get the radius of the tire, the circumference of the tire, the diameter, and then what you do is you divide that by 63,360, which is how many inches are in a mile, and that'll tell you how many revolutions that tire is going to make in a mile. And that's, between these two, it's relatively different.
And the speedometer is set to measure that with a P265.
Assuming that that it was calibrated properly from the factory, yes.
Okay.
It's 200.
Not a 285.
Not the 285.
So the effect is that the speedometer, because it does not know that it's got a 285, it's not giving an accurate speed.
Correct.
And it would be, the speedometer would read slightly, you wrote slightly slower than the actual speed.
Yes,
At one point, you did this calculation,
I did.
and what was the speed that you came up with that the speedometer would have been saying, assuming it's calibrated?
At the beginning of this entire event, I calculated that the speedometer would indicate roughly 79 miles an hour, approximately.
Now, that is using the 83 mile an hour calculation that you came up with later that I'm going to ask you about here, right?
Yes.
Okay. So, through the course of your investigation, you did a speed calculation where when the car goes off that median like we saw in the yaw mark, it's going about 83 mile an hour, correct?
Correct.
All right.
Well, at the beginning of the yaw, it's 83 miles an hour. When it's going off, I believe when it's going off the eastbound lanes into the median, it was at 76.
Yeah, no, I'm talking about the very beginning.
Very beginning, yes,
Okay,
I
and so-
calculated 83.
When you say 79, you're basing it on that 83 mile an hour calculation, correct?
I am, yes.
Okay. All right.
So you didn't calculate, you didn't calculate the speed
Yes, I did, Your Honor.
to come up with 83?
Yes.
Oh, okay.
We're gonna get there.
Oh, all right.
I just wanted to explain, right now, the testimony.
it.
Okay. All right, now, there's been some testimony about the airbag control module in this case.
Yes.
The Dodge didn't have sensors for a side impact, and that the Aveo did record an event. We've seen some of those numbers. Now, you used some of the data from the Aveo in some of your calculations, correct?
I did, yes.
Okay. Just going back to, before we move on, you wrote here, could have affected the stability of the Dodge. When we're talking about the tire size. What do you
Yes.
mean? What do you mean by that?
Once the center of gravity is raised, vehicles have control stability issues. If you're raising the vehicle, you're extending the suspension in that vehicle. So if you turn very quick, it could affect the stability and the propensity for the vehicle to roll. Even though it's only a couple inches higher, it could affect that.
Would there be a feeling in the steering wheel that would indicate stability of the driver?
Possibly that would be whether or not what the speed of the vehicle is and how sharp of a turn. There could be. Yes.
What would it feel like, that instability in the steering wheel?
It would feel as though one of your tires is coming off the ground because you're basically extending the suspension. So instead of having the full weight, that portion of the weight on that tire, it's essentially extending the suspension, and it could be, for a better lack of term, sloppy. It could be a very loose steering.
Loose.
Yes.
Okay. Is that something that you would feel at a lower speed or a higher speed?
It would be more indicative at a higher speed,
Like
a lower speed.
Could you say what speed?
No, I can't really say to within a
Okay.
reasonable degree of scientific certainty, but higher speeds.
So, could you say within a reasonable degree of forensic certainty that the higher speeds, it's more pronounced, that instability in the steering wheel?
Yes, it would be, coupled with the type of turn you're doing.
Okay, so if you have a more drastic or severe movement of the steering wheel, it would be more pronounced, is that right?
Yes,
Because of this tire size?
correct.
What kind of movement of the steering wheel? Are you talking moving from lane to lane, or switching lanes, or?
Any type of movement, any type of sharp turn, just whether you're switching lane to lane. If you gradually do it, you're probably not going to feel it. If you do it a little quicker, you may feel it.
A sharp turn.
Yes.
So when it says, let's see what we got there. Could have affected the stability, you testified about, with a turn.
Yes.
That would have had, if you're driving straight, would it have any effect on the stability of the car?
More likely than not, no.
So just with sharp turns?
Just with any type of turns, sharper are going to be more pronounced. but with any type of turning.
Stability, how are you defining stability here? Are you talking about the vehicle upon the roadway, or are you talking about whether or not the steering wheel feels loose?
I'm talking in stability, I'm talking the propensity for the vehicle to roll,
What do you mean roll?
to go over on its side and to roll over.
Okay, so you're talking, when you are testifying and using the term stability, you are using it in the sense that the tires leave the roadway.
Objection.
Sustained.
What are you talking about more specifically as it relates to the tires leaving the road and stability?
That whichever way, however you're turning, the stability of the vehicle, you're gonna raise, again, you're gonna extend that suspension, and you may have the propensity to raise that tire off the ground, which is gonna cause sloppy type of steering. You're gonna feel it, you're gonna be loose steering.
Okay. All right, I'm going to ask you about some of this ACM data here. You did consider some of the statements that were made by people. We've heard some testimony from witnesses, so I'm going to skip that section here and move on to crash analysis and speed calculations. Okay. Now, this is at page 16 and 17 of State's Exhibit 30. When you began your testimony, I asked you some questions about crash phases.
Yes.
Okay, and I asked you whether or not you did a calculation.
Next question, go back to the tires.
Sure.
In your experience, how common is it to come across trucks that have larger tires on it than maybe what was the manufacturer suggest?
Somewhat common, especially with trucks. Some people put the lift kits on them, which is gonna raise it even more. It didn't appear this truck had a lift kit on it, just the larger tires. The lift kit is what raises your suspension.
Okay.
So it would raise your your leaf springs and whatnot, and raise the truck higher again off of the frame. So in this instance, it appears as though the truck is staying the same distance off the frame. It's just the frame itself, and the truck is higher with the higher tires.
Is that unusual, or is that?
I wouldn't say it's unusual. I've seen it before.
But it's not common, I guess you're saying. Well, I don't know. I don't have to put words in your mouth. You've seen it before.
Yes, I've seen it before.
Okay, go ahead.
Thank you, Judge. Mr. Cronin, I'm going to ask you to explain your crash analysis and speed calculations. Now, I want to ask you questions about it in a true direct examination fashion, but I really think Mr. Cronin does a better job of just explaining it, Your Honor. So, you know.
I'm assuming Mr. Matthews would like that as well.
Yeah.
Yes,
Okay.
please.
Thank you very much, Your Honor. Thank you, Mr. Matthews. Mr. Cronin, please explain the crash analysis and speed calculation. Yeah.
Okay.
Okay. Thank you very much.
So as I indicated earlier, when you do a crash reconstruction, you work backwards through the chain of events. So I start at final rest.
Now, before you start, would you prefer that I go to your tables on the next page to explain? Would that be more instructive?
Actually, I can go through this and I can reference.
Okay. Well, I need
That-
the judge to be able to
Okay.
see the table. So you tell me, if you want that table on the screen, if that is more instructive for the court, then I'll put that up there, sir. And I'll ask you to go ahead and explain what you did.
Okay, we can start with this and then we'll go.
Yeah, you just tell me what to do and I'll do it. Go ahead.
Okay, so what I did with the data that was provided to me, I was able to position final rest of both vehicles and the area of impact from both vehicles. I measured that distance. What I was trying to get was a speed of what these vehicles were at disengagement.
Why? What is your overall, what are you going to do here overall? And then explain the steps.
Okay, I'm working back through the phases of the crash. So I'm working on the speed in the post-crash phase now. The post-crash phase is disengagement to final rest.
Okay.
Disengages when cars come apart?
When they come apart. So I actually used some of the data from the ACM from the Chevy It gave us a speed of the vehicle in half-second increments. It also indicates when the brakes were depressed on that car. The brake pedal was depressed at 1.5 seconds prior to what's known as algorithm enable.
Which car?
The Chevy.
Now, the ATM data, the only usable ATM data for your calculations came from which car?
The only usable data we got was from the Chevy.
So anytime you're talking about ATM data, which car are you talking about?
I'm talking about the Chevy Avail.
Okay, thank you, sir. Go ahead.
So the data from the Chevy indicated that approximately 1.5 seconds prior to algorithm enable, the brakes were depressed. What algorithm enable is that is basically when the airbag control module sensors wake up. They sense a change in velocity or change in speed over a short period of time. It wakes up the sensors and it decides whether it's going to deploy airbags, whether it's going to take up your seatbelt pretensioners, all your safety systems and your supplemental restraint systems in your vehicle. And deciding on the severity of it, depending on the severity of it, it will act accordingly. In this case, it did deploy the airbags. So that is algorithm enabled. That's where the sensors actually wake up and say, okay, we have to make a decision here. The data provided goes 1/2 second prior to. What I was able to do is take 1.5 seconds to the half second, which gives me 1 second of time, and I have a known speed at that time. I was able to calculate the deceleration factor for the Chevy during that portion. Then what I did is I continued that for another 1/2 second, which would be the algorithm enable, and that's how I came up with an impact speed of the car. And then what I did is for
You can
this...
use your pointer too if you need to, sir. Go ahead.
Pardon me?
I said you can use your pointer too if you need
Okay.
to. Go ahead.
And then what I did is I took that same deceleration factor that the Chevy had, and I used that to determine that the speed, now I have a ending speed and I have a deceleration factor. I can get a speed at the beginning of that segment, which would be disengagement. So if you could actually turn to the next page.
Yes, sir. We're going to the bottom of the next page, I take it, or the top?
The bottom of the next page, please.
Okay. All right, and that would be, what figure are we looking at here?
That would be right here, disengagement. So my calculations from the data provided by the ACM of the Chevy indicate, once I did the calculations, that when this vehicle disengaged, when these two vehicles parted and went their ways to final rest, that vehicle was doing 31 miles per hour.
Okay, now when you say that vehicle,
The Chevy.
we're talking about right here, the 2009 Chevy, and so I'm going to highlight, figure 15 is the Chevy, correct?
That is correct.
Okay, now, figure 14, above that, what car are we talking about with figure 14?
Figure 14 is the 2008 Dodge.
Okay, so I'm asking you that just so we get our bearings here. So you calculated the speed of the Aveo at disengagement to be about 31 miles per hour, is that right?
Correct.
All right, go ahead, sir.
And then what I did, if you want to go back to the,
Yes, sir.
back to that,
All right, so now, second paragraph, correct, impact phase we're looking at now?
let me see where it is.
Yeah, we talked about the speed.
Well, I did not talk about the Dodge though. So the
Okay.
Dodge traveled approximately 47 feet from area impact to final rest. I was able to calculate that speed using the same methodology at the disengagement speed was 26 miles per hour. So if we go back to the chart, the top chart, that would be right here. Final rest is 0. I was able to calculate the speed at disengagement of the Dodge at 26 miles per hour.
Okay.
Then what I did is I calculated the speed through the impact phase. The ACM data from the Chevy gives you lateral and longitudinal delta V. And what you do is that is after the crash, milliseconds after the crash.
All right, please explain what delta V is.
Delta V is your change in velocity or your change in speed.
Okay.
So what I did was I calculated, I believe it was at 70 milliseconds after the crash. 70 milliseconds, or 70 milliseconds into the impact phase, rather. That's going to give you your delta V, your change in velocity. So the Chevy, sorry, if we go back to the bottom illustration on that page.
Figure 15, correct?
Yes, figure
Okay.
15. The delta V, and this was calculated through the ACM data, the delta V for the Chevy was 29 miles per hour. So we now have a disengagement speed of 31, and we have a delta V of 29 miles per hour
At impact.
at impact.
Okay.
So that's actually maximum that impact is at maximum engagement.
All right, please explain what maximum engagement means.
So maximum engagement is when the vehicles coming into the crash have equal and opposite forces. That's basically Newton's law of the equal and opposite. I believe it's Newton's third law, action-reaction. So the energy that these vehicles bring in at maximum engagement are equal. So what I then did was I calculated the kinetic energy being brought into this crash by the Chevy, by its known weight, and by its delta V, its change in velocity, and I was able to calculate the delta V of the Dodge with its known weight. So I was able to calculate that. So if we move up to the next, back to the
14.
figure 14, I'm sorry, the delta V on the Dodge was only 14 miles an hour. It's a 14 mile per hour delta V, a change in velocity. And here again, as I'm doing this, I'm seeing how this crash goes. Everything has to kind of line up and make sense. So as I'm doing that, I see how the vehicles impact. The impact, as we saw earlier on some of the photographs, the impact to the truck was on the rear driver's side, at the bed of the driver's side. So that would be consistent with a slighter delta V, because it's going to rotate around it's going to rotate around the center of gravity of the truck. So the delta V is not going to change that much. So then what I did, when I had my delta V, if we go back to the wording portion of it, I'm sorry.
Not at all. Don't be sorry. Page 16, sir.
Yes. So go up a little bit, please.
Yes, sir.
So again, using that, the kinetic energy formula at the, I was able to calculate the speed of the Dodge at 42 miles an hour at impact. So there's actually formula for your delta V, what the speed of the vehicle would be with your delta V and your weight. And that was calculated too, if we go down to figure 14 again. Right there, so I was able to calculate with my known delta V, I can get delta V and I can calculate the weight of the vehicle, and I will get the speed at impact. So again, impact is where they're first making contact. That's where these vehicles first touch. That's not maximum engagement, that's just your impact. And if you go down to figure 15, I was also able to calculate that for the for the Chevy. And the impact speed for the Chevy was 60 miles per hour. And that we know from the ACM data that we received through my calculations to get the impact speed for that. As far as the Chevy, the brakes were depressed about a second and a half prior to algorithm enable. At that time, the speed of the Chevy was 75. At the beginning of the data that we had, which was 2.5 seconds prior to algorithm enable, the speed of the Chevy was 76. And that was all off the ACM. I did not do any further calculations with that. So if you want to go back up to figure 14, what I then did was I measured the distance from the westbound lane to the area of impact. So as it leaves the median, leaves the grassy median, I was able to take that distance and take the ending speed of 42 miles an hour, and the distance that it was, I don't know offhand what the distance was. The distance, the speed that it had as it entered the westbound lane. It's leaving the median, entering the westbound lane. The speed of the Dodge was approximately 48 miles an hour. And then what I did was I calculated the distances that it actually furrowed and rotated and slid across the grassy median. And as it entered the median from the eastbound lanes, I was able to calculate a speed of 76 miles per hour. And what I then...
Excuse me, as it entered the median from the eastbound lane?
From the eastbound lanes.
Okay. And
Yes,
how
as
did you
it,
get that-
essentially as it drove off the eastbound lanes into the median, I calculated that speed to be approximately 76 miles per hour.
Okay. I interrupted you. Go ahead.
That's okay. And then for the yaw, what I did was the highway patrol had distinctive road marks that they plotted when they took their forensic mapping. So I put those over a scaled drawing, and then through the use of expert autostats, I have the original manufacturer specification of the Dodge. So I did the width, the wheelbase, and the overall length of it, and I was able to actually place the vehicle over the 4 distinctive tire marks. What I did then is I documented where the center of gravity was on that vehicle, and I drew an arc line through there. I took a chord and the middle ordinate from that, and through that I was able to determine the radius of that turn, and in turn, from the radius, I could indicate that the speed at the beginning of that yaw was 83 miles an hour.
And what causes the yaw mark?
The yaw mark is from a tire rolling forward, sliding sideways, which would mean the wheels turn is kind of going in a little bit of an arc.
Right.
And to get a speed from that, you need to find the radius of that, so you need to find the chord in the middle ordinate.
So that's the earliest you're able to determine the speed of the truck?
Yes. That's at the beginning of the
That'd be
yaw
the
mark.
very first yaw mark?
Yes. Yes, the one that was illustrated in the image, in the figure before.
Would it be, in order to see this visual, you're familiar with Sergeant Fox's reconstruction report, correct?
I am.
Okay. Would it be helpful for me to show you some of those diagrams in terms of the placement of this yaw mark?
Yes.
Okay. If I may, Your Honor, this would be, it's Exhibit 25. This is the reconstruction report of Sergeant Fox, Ohio State Highway Patrol. Mr. Cronin, I'll ask you to look at the monitor and just tell me, would this be the best image to describe the placement, or
Yeah.
like another one? This
Yeah.
one?
Yeah, that
Top of
image.
the screen? The middle of the screen, I mean?
Yes.
Okay. Your Honor, this is page 8 of 30 of the crash reconstruction report of Sergeant Fox. Now, Mr. Cronin, I asked you earlier about Faro
Yes.
program, okay? And there's been some testimony in this case that the troopers use a different program to plot these points. Are you familiar with what that program is?
I believe there's this Trimble.
Okay, all right. Now, there was testimony that these points are plotted using the Trimble program.
Yes.
Okay. And then I asked you earlier about Faro.
Yes.
Did you also plot these using Faro?
I plotted the majority of them. There's a lot of points I did not plot.
Okay. The diagram that we see here on page 8 of 30, does this help demonstrate the beginning of the yaw mark?
Yes.
Okay. Go ahead, sir.
So, in relation to the speed, right here would be where the speed was calculated at 83 miles an hour. The vehicle begins to turn and rotate. Right here, as it goes off the eastbound lanes into the median, that's where I calculated my speed to be 76 miles an hour. As the vehicle went through the grass median, came out right here into the westbound lanes, that's where I calculated the speed to be 48 miles an hour. Right here at impact is where I calculated the speed to be 42 miles an hour. And then at disengagement, right here before the vehicle slides to final rest, is where I calculated the speed to be 26 miles per hour, if that makes it any easier.
Okay, yes, sir, thank you. And, Your Honor, if I may, for purposes of the record, when Mr. Cronin was beginning to explain what he just did regarding his speed calculations and the relative placement of the truck, for the record reflect that when he said right here, that first point, 83 mile an hour, is that first to the left, that red truck, right, would be above the letters D and E,
Right.
the word movement.
It's the far left red truck on the diagram.
Yeah, thank you, Your Honor. You reached some conclusions, having reviewed the data and done your calculations and investigations, correct?
Yes, I did.
Those conclusions, are they documented in your report?
They are.
Right, that would be on the last page, correct?
That is correct.
All right. Now, did you form an opinion based on your investigation of the proximate cause of this crash?
Yes.
What is that?
The proximate cause of this crash, in my opinion, was Mr. Klotz failing to maintain control of his vehicle.
All right. The opinions that are expressed in your report and your testimony here today, are they all made within a reasonable degree of scientific and reconstructive certainty?
Yes, they are.
If I may have one moment, please, Judge.
Sure.
No further questions, Mr. Cronin. Thank you very much, Your Honor.
Thank you.
All right, cross-examination, Mr. Matthews.
Thank you, Your Honor. Could I have just 1 second to
Sure.
give Mr. Klotz? Thank you, Your Honor. Good morning again, Mr. Cronin.
Good morning, sir.
These oversized tires, with that increased center of gravity, could it make the vehicle more difficult to control in an oversteering situation?
The difference in the height of the center of gravity?
The additional height and that perceived instability that you talked about in steering.
Yes.
If you were in an oversteering situation, would that, the height of those tires make the vehicle more difficult to control?
Yes.
Would you repeat that question? If you were what?
If you oversteered,
Oh, if you were in an oversteering situation?
yes, the height of the tires would affect the control. So then by definition, I guess they would make a correction to an oversteering more difficult to control also.
Potentially, yes.
So the factory recommended passenger tires for this vehicle.
Yes.
And as you said, it had light truck tires. And you went through some of the differences. What about the difference in tread between passenger tires and light truck tires?
A light truck tire has a much more aggressive tread design.
When you say aggressive, do you mean deeper?
Could be deeper. There could be more ruts and grooves to dissipate water, mud, dirt. A lot of them are designed for essentially off-road use, so it's gonna have a more aggressive tread design, whereas your passenger car may just have a couple little grooves or whatnot to dissipate the water.
All right, but in terms of the depth of the tread, you saw the photographs of the tires that were
I did.
on the dock.
Yes.
That tread on that tire doesn't look like the tire on my Chrysler 200.
No, I'm sorry. If that's your question, yes, the depth of the tread
Yes.
on the tire is gonna be deeper
Yes.
on a light truck tire, yes.
Okay. All right. Now, these tires, when you saw the photos, they appeared to be in pretty good condition,
Yes, they did.
like relatively new looking.
Relatively, yes.
Are you familiar with the concept of tire squirm or tread squirm?
What's the word you're saying?
Tire squirm?
Squirm?
Yes. Or tread squirm.
I've never heard of that terminology before.
What that term describes is the tendency of a newer or a deeper tread tire to, because of the depth of that tread.
Is this a question
Well,
or testimony?
what I'm attempting to do is describe this condition and see if
Never heard of it.
I'm wondering if he's heard of it in a different
Okay,
term.
good. Okay.
It's a term that describes when a tire is relatively new and has a deep tread, that the flexibility of that deeper tread can create potential slippage of a tire while driving. Are you at all familiar with that
I have not heard of
concept
that.
at all? Okay,
No.
in no way, shape, or form. All right. You said the higher center of gravity could affect the propensity of the truck to roll.
Yes.
And you said it could make the driver feel like the tire was coming off of the ground.
Potentially, yes.
Okay. And that the steering would feel loose.
Yes.
Now, you said in some instances you've seen trucks with larger tires that had a lift kit
Yes.
on them. What is the purpose of that lift kit?
Aesthetics. As far as, I don't understand the question.
Well, does the lift kit in any way better, I guess, equip the truck to have oversized tires put on?
It could potentially, yes.
I mean, would the lift kit compensate in any way for
No.
the, okay. All right. And these yaw marks, they are indicative of the truck moving forward, but also sliding
Correct. Beginning of slide sideways.
at the same time.
Yes.
Okay. What about the effect of low tire pressure in these tires?
Low tire pressure could have an effect on it,
And what effect would that be?
depending on which tire it is, whether it's on the right side or the left side and which way you're turning. In this case, for instance, if there was low tire pressure on the right side, either the front or rear tire, as the vehicle's turning, that you get a lot more weight in there. So what it's gonna do is gonna push the tire and compress it. It's gonna make the footprint of the tire wider. If you have low pressure on the left side in this instance, what it's gonna do is it's gonna make the tire essentially extend the suspension to its maximum limit sooner.
Can low tire pressure contribute to, I guess, a loss of control of a vehicle?
Yes, it could.
No further questions, Your Honor.
Redirect examination?
Thank you, Your Honor. Mr. Cronin, you testified about the effect of the size of the tires in the vehicle affecting stability. You spoke in terms of the speed, correct?
Correct.
Okay. And Mr. Matthews asked you some questions about whether the center of gravity makes it more difficult to control the car, and you indicated yes, it can, correct?
I did, yes.
Well, okay. You said in an oversteering situation, it would make it more difficult.
Yes, oversteering and speed. Initially, when I spoke, it was the speed and it would be both.
If it wasn't in an oversteering situation, would it have an impact?
Likely no.
Go ahead.
Thank you. How does the rate of speed correlate to that difficulty in control?
I'm sorry.
Let me ask it a different way. If you are going slower, is it more or less difficult to control the car?
Oh, it's going to be it's going to be less difficult to control the car if you're going slower.
Okay. Is it true that the faster you go, it's harder to control the stability of the car?
Yes, that's correct.
You've been doing crash reconstruction since 1999, is that right?
That is correct, yes.
You never heard of this tire squirm or tread squirm?
I've not heard of that term, no.
And neither of the concept of it as explained by Mr. Matthews, you never heard of that?
No, I haven't.
Okay. In your analysis of the crash and in your investigation of this crash, did you examine tire pressure?
I did not know.
Okay. Is there any way to tell from the yaw marks that you saw photographs of or measurements taken of that would give you any clue about tire pressure in this case?
Yes, as I explained to Mr. Matthews, if you have low tire pressure, in this case, if it was on the right-hand side of the vehicle, as you're turning...
So let me stop you for a minute. You explained the concept to Mr. Matthews, but I'm asking you, do you recall any of the data that you reviewed that would show evidence in this case of tire pressure having an impact on the defendant's driving?
No, I would expect to see a wider, more prolific tire mark had there been low tire pressure, and that wasn't present here.
Okay. Thank you very much.
Cross-examination.
No questions, Your Honor.
All right, sir, thank you very much.
Thank you, Your Honor.
Give me 1 second, please. All right, state may call its next witness.
Your Honor, the state has no further witnesses to call. All of the state's exhibits have been introduced into evidence. So at this time, the state would rest.
And if I'm correct, all the exhibits have been admitted, stipulated to, correct? In terms
Yes,
of-
yes, Your Honor.
So then all the exhibits, they're admitted. There's nothing else to discuss then on behalf of the state. Mr. Matthews, anything you care to discuss then at this time? You want to make your motion?
Yes, Your Honor, I would make a motion under Rule 29 at this point in time for dismissal of all counts of the indictment. We do not believe that the state has presented sufficient evidence to proceed on these charges any further. I would specifically point to count 8 in the indictment, the vehicular homicide count. The standard that the state would have to meet in this case in proving criminal negligence would be that Mr. Klotz engaged in a substantial lapse from due care while operating his vehicle. We heard testimony that Mr. Klotz had just purchased this vehicle, obviously was unfamiliar with how it would perform. There was no testimony offered that he had any idea that there were these oversized tires on the vehicle that can affect the stability of the operation of the vehicle, affect the stability of the vehicle in an oversteering situation. Mr. Klotz, in his, statements that were made to the Ohio State Patrol, did indicate that the low tire pressure monitor had come on in the vehicle and that he had intended to pull over at the next exit to check the tire pressure. Tire pressure can also contribute to instability. But at its, worst, the state, in terms of speed, the worst that the state has entered into evidence is that at the beginning of that yaw mark, he was going 83 miles an hour, excuse me, when his speedometer would have been reading 79 miles an hour. Now, when we talk about this substantial lapse from the duty of care, we think of things like, is the person intoxicated? Obviously not. Mr. Klotz's statement on video to the troopers indicated he was not on his phone, he was not playing with the radio, he was not distracted, he had slept 7 hours the night before. He didn't run a stop sign. He didn't blow through an intersection. He didn't, run through a red light. All the typical indicators of what would be a substantial lapse from the duty of care while driving, none of those are really present here. He was operating the vehicle. and he lost control of it. Now, if going 79 miles an hour in a 70-mile-an-hour zone is a substantial lapse from the duty of care, I would contend that 90% of people on that stretch of Route 90 are exhibiting a substantial lapse from the duty of care. As we all kind of just know, the speed limit in practical terms is really more of a expected speed minimum by the vast majority of drivers on the road. And if your speedometer is reading 79 and you lose control of a vehicle that was sold to you, by the way, for thousands less than what Carfax says it is worth, we heard testimony from the second representative from the company that sold him the vehicle that drivability and cosmetics are the two biggest factors that indicate the worth of the vehicle. And we saw from the photographs that particularly the interior of this vehicle was in pristine condition. That pretty much leaves drivability as the reason that a vehicle would be sold twice, in fact. Once by Classic and Menor, I think it was, and the second time by the dealership Mr. Klotz bought it from. So when you purchase a vehicle, you're driving it home for the first time. This is the first time, obviously, Mr. Klotz has ever had it up to highway speeds. And at worst, you can say that he thought he was driving 79 miles an hour. With all of the factors that these tires introduce, obviously he lost control. Obviously the conclusion that Mr. Cronin reached is an accurate conclusion. He did lose control of the vehicle. The question is whether or not he lost control of the vehicle because of a substantial lapse of due care. And I do not think that given all of the factors that are present regarding the state of the vehicle with the tires that were on it and the issues that that can create in terms of the ability to control the vehicle, that we can say that there was any substantial lapse of due care. We would ask that that charge not proceed either.
Should appear up the state.
Thank you, Your Honor. As it relates to Rule 29, in the light most reasonable, excuse me, that the state reasonable minds can come to different conclusions about any of the elements of these offenses, excuse me, and the Rule 29 motion was made relative to each and every one of the counts in the indictment, so I'll address those. And we have date, venue, identity of the defendant, fact that he was under suspension. Not in dispute here. Count 2 and Count 1, the falsification, state presented evidence to meet those elements. Signing that document, an attestation of the statement that he had insurance for the car that he just bought. He's applying for a license. That's a falsification. He did it on a form that is kept by the Ohio BMV. It's a governmental entity. And he did it so that he could get a plate for the car and drive away, knowing that he didn't have insurance. That is a fraud that he perpetuated on the BMV, on this government document. It even has a form number on it. The state's exhibits include the application that he signed and the certified copy from BMV records themselves and the testimony of the person who certified those. As it relates to Count 3, Your Honor, the driving under suspension, this is a non-compliance suspension. It's the third listed suspension on his criminal history. It's the State's Exhibit 5 at page 3. That relates to financial responsibility laws. It's in the law at 4509.101 that this is that sort of a suspension, so that's a matter of law when you apply it to the facts here. Speed limits ample evidence testified here that the defendant was at least exceeding 70 mile an hour in a 70 mile an hour zone, and that the speed he was going at was greater than reasonable or proper, having regard for the traffic, and then he lost control. The totality of evidence shows that, Your Honor. He caused Mrs. Wise's death, this approximate result of a number of factors. Any provision of Title 45 that he violated that caused her death would fit speed, reasonable control, marked lanes, as it relates to the vehicular manslaughter, count 7. But count 8, Your Honor, negligently. We're talking about negligence, not recklessness. So when Mr. Matthews is talking about OVIs or running stop signs or other factors like that, you know, that's more of a recklessness, or you know, he didn't know that the tires were too big or that the center of gravity was off. If he knew those things and he ignored it and he said, to hell with it, I'm going anyway, that would be recklessness. The fact is that he should have realized these things and he should have been more careful. He's going too fast. We have the speed calculation at the beginning of that yaw mark that he's going 83 when he starts to lose it over the median, but we also have the testimony of the people that were driving by him. This is a Friday rush hour on I-90. He had at least 1-2 cars behind him where Ann Cellini saw. He had at least 1-2 more cars in his near vicinity because Ann Cellini saw him drive from one lane to the other and back to the other. He's switching lanes, and she said in the 911 call he's driving crazy, passing cars. All of these factors go into his negligence, Your Honor. And yeah, you just got that car. You take it easy. You don't go 83 mile an hour. And whether he's looking at his speedometer and it says 79 or not, he sees that the cars around him, what they're doing. Laura Jones testified she was going between 60 and 65 mile an hour. She testified. Not every car on the road there was barreling down the road at 80 miles an hour, Judge. And that was right by him. Should have been more careful. That's a substantial lapse of due care for purposes of Rule 29. Thank you, Judge.
Thank you. Well, at this stage, ruling on this motion, the court must consider all the evidence in the light most favorable to the non-moving party, that being the state of Ohio, and in doing so, the court at this time will overrule that motion, the defendant's motion, as to all of the counts. So, Mr. Matthews, what is the defendant's intention at this time in regards to the presentation of evidence? Or do you need time to talk with your client?
I would ask for some
Right.
time to talk.
All right, let's take a little brief break and let Stan know when you're...
Thank you, Your Honor.
Let me think for 1 second. If it's your intention to present evidence, let Stan know. If it's not, let Stan know also. But then we'll take a little break, and we'll take a break to, use the restroom, whatever. And then if you need a few minutes to get your thoughts together and stuff too, we'll do that. So just let Stan know when you make a decision regarding presentation of evidence, and then I'll make a decision as to what we're going to do next.
Very good, Your Honor. Thank you.
regards to the presentation of, evidence,
We will be presenting no evidence, Your Honor.
so you rest at this point?
We are resting.
Very well. For the record, you want to renew your motion?
I would, yes, Your Honor, renew my Rule 29 motion. I would incorporate all my previous arguments into this motion.
I'm of course going to overrule that at this time. Are both sides prepared then to proceed with closing arguments?
Yes, Your Honor.
Mr. Mayor?
Yes, Your Honor.
All right, then I will hear from the state. Mr. DePiero?
Thank you, Your Honor. I believe many of the arguments you're going to hear now are going to be similar to some of the arguments made at the Rule 29 motion and the response. The date, the venue, the identity of the defendant, Your Honor, he was under suspension. These are all matters that are not in contention here. They're not being disputed. Here we have a situation where we have a man who found a truck that he could afford, that he had cash for so he could do some jobs, and he was in a rush to get that car. He got it, knew he shouldn't have been driving, knew he didn't have insurance, and he drove anyway. We have a situation where he falsified and he tampered with records. Now, as I said earlier, signing that document in State's Exhibit 2C, that's the temp tag application that the defendant signed, that is an attestation of the statement that he has insurance for this car that he just bought. And he's asking the BMV for permission for a license, a permit, a license. So that is a falsification, but it is more. It is more. He knew that he was defrauding the BMV. We know this in part because he told the troopers that he had contacted this freeway insurance company. He's in the back of the car, they're asking him about insurance. He says, freeway insurance. Matter of fact, Your Honor, if you look at the defendant's written statement, he even writes the name freeway and he puts a telephone number there. This is important because it goes to his mens rea when he's signing that document to get that temporary tag. And when he signs attesting that, yes, I affirm that I have insurance on this car, he knows he doesn't. State's Exhibit 2C is the same form as State's Exhibit 3C. 3C is Investigator Reisch testified, Your Honor, about the document that the BMV keeps. He got it from the data from the BMV. It is the temp tag application that JE Auto Works created when they created the paperwork to sell the car to the defendant without the signature on it. It's kept by a governmental agency. There was testimony. BMV is under the Ohio Department of Public Safety. It has a form number at the bottom, left-hand corner. It says BMV 4349. Clearly, it's a government document. It's kept by them. That makes this a tampering with records of a governmental entity. The defendant is very forthcoming about the fact that he's under suspension. When he went to go purchase the vehicle from JE Auto Works, he got a ride there, got out of the car. Mr. Loftman approached him to greet him, and he wanted to buy that car right away, and they made him drive it because it's their policy. They sell cars as is. They want to make sure that people can get behind that wheel. They don't want to buy it. They don't have to. And there was testimony that he did drive this car. If you remember, had the photograph, Your Honor, where we had the parking lot, and he went up the street, a few driveways, came back. Mr. Loftman even remembered that the defendant, forget his exact words, but indicated that the defendant really hit that gas, test it out, see if it can go. All the evidence was that the gears shifted, the brakes worked, there was no mechanical issues when it was at that car, regardless of what Carfax says that it's worth. They sold it to him for $2,500. He had an opportunity, he drove it, and he chose to buy it. Now, the non-compliance suspension, as I stated earlier, Your Honor, State's Exhibit 5, page 3. It's the third listed suspension. That relates to a financial responsibility law suspension. The revised code section is 4509.101. That's how it relates to the noncompliance to the law for purposes of a verdict here. Again, that's not in dispute. Now, talking about the counts 4 and 5 and 6, the speed limits counts and the operation without reasonable control counts, I think that I'm going to talk about all of those in conjunction with the vehicular manslaughter and the vehicular homicide. Certainly, Your Honor knows that the difference between counts 4 and 5 are that count 4 is the actual that you exceeded the posted speed limit, and count 5 is you're driving too fast for the conditions. Ample evidence that the speed limit there is 70 mile an hour at mile marker 204.4. And well before that, Your Honor, actually after you pass Route 44, up till you come to Vermont Road. Even though the defendant tells the troopers multiple times on video he's going between 65 and 70, and he adopted that and when he signed his written statement as well, he wasn't going 65 or 70, Your Honor, because Ann Cellini remembered she's going 74. She said her cruise control just less than 5 mile an hour, because in her mind, you're going to get a ticket, you're going 5 mile an hour over. That's very good memory, Your Honor. I think that, you know, the fact that she practices that is relevant in terms of getting a real-life depiction of what was going on the freeway, because we have two people in here who testified. One was going 74, one was going between 60 and 65. Now, Ann Cellini, when she testified she was going 74 mile an hour, she testified that there were two cars, at least two cars, and then the truck. The truck didn't really jump out at her until he started crossing lanes. Her testimony very clearly, Your Honor, though she said it was abrupt, she testified that the defendant went from the left lane, moved to the right lane, back to the left lane, and when he went over to the right, that's when the truck shifted and he went out of control. Mr. Matthews asked her about that. I believe he used the word was that he moved boom, boom, boom. And then I asked her on a redirect, with each successive boom changing the lane, did the defendant pass a car? And she said yes. That is not a coincidence. That is control of the vehicle. She called 911 in a panic as soon as it happened. Your Honor heard that. It's in one of the state's exhibits, where she described the driving that she had just witnessed and said he was changing lanes, he was driving crazy. That hasn't changed with her testimony. Perhaps more specific and precise about the exact movement and placement of cars now. But that impression remains the same with her testimony. Laura Jones, Your Honor. And these are two people that have kids in the car. I mean, Ann Cellini has got her grandson. Laura Jones has her son in the car. They're going about their way on 90. And in rush hour traffic, you have testimony about multiple cars in the vicinity of this truck. He's going too fast for that. She's going between 60 and 65. Perhaps he's trying to pass her when she was in the right lane. Perhaps he moves over to the right, sees her going slow, moves over to the left. But she testified that her perception of the defendant driving in the left-hand lane and flying past her at a high rate of speed was that it was imminent that he was going to strike a car that was in front of him. And it was so striking to her that she slowed down and moved over. All right, so that's another car that's right in front of the defendant. He's going too fast. He loses control of the car. He oversteers. He knows that. He told the troopers, I may have oversteered. He did. Regardless of the size of these tires, when you're going that fast and you have to cut it over where you're almost hitting somebody that you should have seen, that's a substantial lapse of due care in your driving. So any one of these minor misdemeanor Title 45 offenses contributed as a proximate result to the death of Catherine Wise for the vehicular manslaughter, Your Honor. As Mr. Matthews mentioned in Rule 29, The pivotal issue here is negligence. OJI refers to the statute. There's an OJI section that defines negligent, and it parrots the statute. It's 290122D, as in David. Your Honor has seen it many times through the years. A person acts negligently when, because of a substantial lapse from due care, the person fails to perceive or avoid a risk that his conduct may cause a certain result, or may be of a certain nature. A person is negligent with respect to circumstances when, because of a substantial lapse from due care, the person fails to perceive or avoid a risk that such circumstances may exist. This isn't about whether the defendant took a ruler out and measured the tread depth of these tires when he bought the car. He failed to perceive or avoid a risk because of how he was driving that car. And this was less than an hour that he owned this car, Your Honor. This was a matter of minutes. It's unfamiliar to him. Regardless of the condition, it's unfamiliar. You take it easy. You don't go 83, you don't go 79, you don't go maybe even 70. It's unfamiliar to you. This is a large, big truck. It's a 1500 Ram. You're in rush hour traffic with cars all around you going variable speeds. He was going too fast to control his car. We're not talking about recklessness. The state does not have to prove recklessness. He doesn't have to prove that he knew these things, but he said, I'm going anyway. That's recklessness. Negligence is, because of a substantial lack from due care, he failed to perceive or avoid a risk. He should have been more careful driving. He was going too fast. He was switching lanes, and he lost control of that car because of it. That's negligence. That's vehicular homicide, Your Honor. Thank you.
Thank you. Mr. Matthews for the defense.
Thank you, Your Honor. I guess I'll begin by just going through the indictment. Count one, the tampering with records. I do think that there is a substantial equity argument to be made against finding Mr. Klotz guilty of count one. There is a charge of falsification, count two, that very clearly outlines the conduct that Mr. Klotz engaged in. In fact, states Exhibit 3B, right on the temporary tag indicated, this is the state-generated document, that false statements can result in prosecution of falsification, a misdemeanor of the first degree. Now, this is the same legislature, same state that created the tampering with records statute, and they chose to put on their document that the penalty for falsifying it is falsification.
Should the legislature created that document?
Well, a state body, I guess, created the document. And it was clearly printed on there that that is the penalty for falsifying that document. Therefore, we are not contesting count two, falsification. We do feel that is the appropriate charge rather than count one. Count three, driving under suspension, well, he was under suspension. So we are not going to contest that point. Count four, the speed limit, the count that is alleging that he was driving over the posted speed limit, I don't believe that there's reason to contest that. We can accept that he was driving over the posted speed limit in count four. However, count five is a charge relating to speed essentially that is greater than what would be reasonable or proper, having due regard to traffic, surface, and the width of the street or highway, or any other conditions. Now, we heard that this is basically a perfect set of driving conditions. It's a warm day, no rain, no sun glare coming at him. To be operating a vehicle at a top speed of 79 miles an hour, according to his speedometer, which is all that he has to go by, in a 70-mile-an-hour zone with optimal driving conditions, I do not believe that it can be said that driving 79 in a 70, again, I apologize. We understand that that wasn't perhaps his actual speed, but that's what he saw or had the opportunity to see on his speedometer. There's nothing wrong with the surface of that road. There's nothing wrong with the width of that road. And there were no other conditions that made that speed unreasonable or improper. So we do not believe the state has proven count 5. Count 6 relates to operation without reasonable control. Now, it is beyond argument that Mr. Klotz lost control of the vehicle. There's no dispute as to that. The question would be, did he act in such a way as to not be in reasonable control of that vehicle? What he personally was able to judge in terms of the way the vehicle was handling. Do I need to turn to correct? Do I need to turn back to correct that correction? Now again, we've got a vehicle that we heard from Intratech's mechanical inspector that he said the alignment and suspension appeared to be in good shape. But he indicated that he based that largely on the condition of the tires, that they had not shown any pattern of uneven tread wear. Well, on relatively new tires, you're not going to see an uneven pattern of tread wear. There hasn't been any time for that to develop. Now, he did indicate that the steering mechanism appeared to be tight rather than loose. So, when you do make a steering motion, there is going to be a faster and greater response by the steering system on a tight rather than a loose steering system. So, and this dovetails also into the negligence argument also. But when you've got, by Mr. Klotz's statement, low tire pressure, and these oversized tires that can reduce stability, that you can have the feeling when you make a steering motion, that according to what Mr. Cronin said, let me just make sure I get it right. The effect of these tires can make the steering feel loose. Now you combine the effect of the oversized tire having the propensity to make the steering feel loose, combined with the system itself being tight. If it feels loose, you're going to make a correction based on what you are feeling, and the tightness of the system is going to amplify the motion that you make. So, in Mr. Klotz losing control of this vehicle, I do not believe that the state has demonstrated beyond a reasonable doubt that his operation of the vehicle, resulting in it coming out of control, was an unreasonable degree of control for what he knew about the vehicle. He did not know the speedometer was reading wrong. He did not know the tires were oversized. He had just gotten the thing. He didn't know how it handled. He didn't know how it was going to handle on the freeway. And he was not driving at an excessive speed. Was he over the limit? Yes. By his speedometer, what information he had available to him, at worst, he was going 9 miles over, which I think we can all just, from our own personal experience, realize that 9 miles over the speed limit is not an uncommon thing. So we do not believe count 6 applies here, and he should be found not guilty. Count 7, while operating a motor vehicle, did cause the death of Catherine R. Wise as the proximate result of committing a violation of the motor vehicle code that is a minor misdemeanor. So, based on the indictment, that would be either of the speed limit counts or the count 6. We don't believe the state has proven counts 5 and 6, and that would leave count 4 just being over the posted limit. And I do not believe that it has been proven beyond a reasonable doubt that Mr. Klott's driving 79 miles an hour, given what he knew about that vehicle, its tendencies, its capabilities, that simply going 79 miles an hour is not unreasonable. Him going 79 miles an hour was not the proximate cause of this accident. The proximate cause of the accident was the loss of control of the vehicle due to circumstances that he was not aware of. This vehicle did not have the proper size tires. It was unstable. That instability led to the steering feeling loose. The structural makeup of the vehicle had tight steering. If it feels loose, but it's actually very tight, you're going to oversteer. If you are feeling as though what I need to do to turn this vehicle, based on the feeling of the steering being loose due to the oversized tires, the structural integrity of the steering system being very tight, that is going to amplify the effect of making that course correction. So we do not believe that his going 79 miles an hour was the proximate result of this accident. And then that leads us to count 8, which really has been the main focus of this trial, Your Honor. And in belaboring the point, I will again say that we have to demonstrate a substantial lapse from due care, and that this has to, of course, be proven beyond a reasonable doubt. There is ample doubt from a number of reasons, that he engaged in a substantial lapse from due care. We can begin with the circumstances under which the vehicle was purchased. The price alone was very attractive to Mr. Klotz, obviously, because it was a low-priced vehicle. But the company, the Auto Works company, the owner indicated that they did no major inspection of the vehicle. He did not test drive the vehicle on the freeway, and that he sells vehicles for thousands less than what Carfax indicates they are worth. And this vehicle was sold for thousands less than Carfax thought it was worth by Classic and Mentor, and it was also sold for thousands less than it was worth by the company he bought it from. Now, when we get to the 2 witnesses that came in and testified about observing Mr. Klotz driving, Ms. Seleni, indicated she was doing 74 miles an hour in the right lane. Mr. Klotz was in the left lane. She testified that he did not blow past her in the left lane. She did not notice him until he began driving crazy. Now, I think it is not at all an unfair extrapolation that what she saw as driving crazy was Mr. Klotz losing control of this vehicle. Now, she indicated that there was a swerve to the right, to the left, back to the right, loss of control. Her interpretation and memory of these events is not supported by the accident reconstruction. The accident reconstruction indicates that trouble began in the right lane when Mr. Klotz's vehicle came over, and these yaw marks are caused by this both forward and sliding motion. The vehicle was beginning to become out of control at that point. As evidenced by the reconstruction, immediately after that point, that is when the vehicle then began going left and then across the median, obviously out of control at that point in time. Now, the other witness, Mrs. Jones, said she was going between 60 and 65 miles an hour in the right lane when Mr. Klotz passed her very quickly in the left lane. Now, all she saw was him go past her in the left lane, which, if you are driving under the speed limit on the freeway, it is far from uncommon. The cars are going to pass you quickly in the passing lane. But then he applied his brakes, and then at that time, the back of the truck started moving from side to side, and that is when he began spinning out of control. Now, this is in direct contradiction to Ms. Delaney's testimony that he was weaving in and out of cars. Weaving in and out of cars, if indeed it occurred, which, again, the reconstruction does not indicate that it did, are you weaving to get around cars? Or if you are out of control, are you weaving to attempt not to hit other cars on the road? Once you have lost control, you've lost control. Ms. Jones indicated that he lost control because the back, well, she didn't, I shouldn't say that. She didn't say that's why he lost control. She said she observed upon his application of the brakes, the rear of the truck started going from side to side. Now, when the rear of the truck begins moving side to side, obviously that is going to be alarming to the driver, and the driver is going to react to attempt to correct. Now, Mr. Klotz also said that when he lost control, he gave it some gas to attempt to regain control. Now, it is likely that it was the action of giving it gas and trying to steer out of this that created that first yaw mark. He may not have been driving at 79 miles an hour based on his speedometer prior to giving it gas to try to get out of this fishtailing which Ms. Jones observed. Ms. Jones does not say anything about him weaving in and out of traffic. She says he was coming up the left lane, which we can assume that he was in control because he just passes her on the left, applies his brakes, and that was when the loss of control began, after that application of the brakes. Now, could there have been issues that were not detected with the alignment, the suspension, because there had not been time for those tires to wear unevenly and show that issue? We don't know. Do these oversized tires with that reduced stability upon braking cause the back of the vehicle to go back and forth? We don't know. What we know is Mr. Klotz was very, very consistent the entire time. I was driving. He assumed there was some kind of mechanical failure because he said he just simply lost control. Now, if the state is going to say that they have proven beyond a reasonable doubt that he engaged in a substantial lapse from due care, again, there were none of the typical things that we would think of, you know, stop signs, intoxication, things like that. So we're just talking about his operation on this particular day of this particular truck. And if at worst, you can say he was driving 79 miles an hour and lost control of the vehicle, if Ms. Jones' testimony is to be believed, after applying the brakes in the left lane and then immediately afterwards losing control, that does not, by any stretch, amount to a substantial lapse from the duty of care, certainly not beyond a reasonable doubt. The fact that he had just got it, that he was unaware of the issues with the speedometer, the oversized tires, and the lack of evidence as put forth by accident reconstruction that he was ever weaving in and out of traffic. They have one movement to the right where at the beginning or through that yaw mark, that is where the vehicle lost control. There is certainly reasonable doubt when it is completely feasible that Mr. Klotz was driving, experienced what he perceived as a loss of control, attempted to give it gas, steer out of it, the oversized tires creating the perception in his mind that the steering was loose, when in reality it was very tight. This led to an oversteer, which could happen to anyone. But that oversteer is exacerbated by the fact that the low tire pressure light was on for one, and he had indicated he was going to address that. But also, as Mr. Cronin testified, that these oversized tires, they can reduce the stability of the vehicle and create that sensation that the steering is looser than it actually is. So any oversteer on his part was amplified by conditions he was unaware of. In the end of this, Your Honor, it's obviously a terrible, terrible tragedy. I think it was clear from listening to Mr. Klotz that he understands the gravity of this. And by the way, when he was in the back of that car, he was on the phone with his wife. There's no way of knowing one way or the other for sure if he knew he was being videotaped. But we've seen plenty of people in the back of police cars exhibiting different behavior than they exhibit when they're out of the police car, when they think they're alone. And when he was alone, there's no reason to believe that he wasn't being completely genuine, that he was not on his phone, that he was not distracted, that he thought genuinely there was some mechanical issue. He had no idea what it was. He said that one of the people that got out of the vehicle said they thought they saw the drive train, whatever the drag. Now apparently that turned mechanically not to be the case, but he threw that out because he was told that that may have been what occurred. But in the end, Your Honor, he really had no idea why he lost control. And he was very consistent about that. And there are more than ample reasons, given the condition that this truck was in and the issue with the tires that he was unaware of, the speedometer that he was unaware of, to indicate that his actions were not unreasonable and that they certainly do not amount to a substantial lapse from due care, and that they certainly do not amount to a substantial lapse of due care beyond a reasonable doubt standard. So, we do believe, Your Honor, that as to counts 1, 5, 6, 7, and 8, the state has not proven their case to be, they have not proven their case beyond a reasonable doubt, and therefore, Mr. Klotz should be found not guilty of those counts.
Thank you. Commissioner Culotta, State.
Thank you, Your Honor. Well, the state has not presented any evidence that the defendant was tired or distracted or drunk. These would be relevant in a reckless analysis. And if the defendant was tired or told, those are light truck tires, the tire pressure's a little low, so take it easy, and he said, to hell with it, I'm going fast anyway, we'd be in a reckless. And I keep bringing up the difference because of some of the arguments that Mr. Matthews made. There's a real difference between negligence and recklessness, Your Honor, and that being a recklessness that you're aware of something, the negligence that you should have been, and you failed to perceive something and avoid a risk. Now, going in line with and responding to some of the arguments that Mr. Matthews made in the beginning of his argument, he's talked about the falsification and the tampering and an equity argument. I'm not sure what he means by equity argument because the law is the law. And everyone's presumed to know the law, and the fact that some bureaucrat at the BMV decided to put that making a false statement on the document may constitute the crime of falsification, that doesn't mean that he's not guilty of tampering with records. And yeah, they didn't take the extra step to go, making a false statement may constitute the crime of falsification and tampering with records, but it's not, you don't get away with it because the form doesn't say that. The state did not present evidence of why that's on there. It can be speculated that maybe the word falsification is scary to the average person. Either way, it's not a pass to commit a tampering with records because it's not written on the form, Your Honor. One of the recurring numbers that Mr. Matthews argues and brings up is 79 mile an hour, 79 mile an hour. If that's all that was known to the defendant, all that he could have known. Well, he didn't think he was going 79 mile an hour. He thought he was going between 65 and 70. At least that's what he told the troopers. So he must not have been looking at his speedometer. He must not have been for all the time that he spent in the back of the cruiser, not knowing whether he's being recorded or not. He consistently said to the troopers and to his wife, he actually told his wife at 7 minutes and 10 seconds into the video, Your Honor, that he was doing under the speed limit, he told his wife on the phone. It's State's Exhibit 21. Said he was going 65 or 70, probably, at 38 minutes and 40 seconds. It wasn't speeding. He says that at 30 minutes, 27 seconds. So, He must not have been looking at his speedometer to see that it said 79, because he says over and over he's going 65, 70. So it's not all that he has to go by, that speedometer. He didn't look at it. And I'm being kind in saying he didn't look at it. There's other reasons he might say that he's going less, but I don't know. All I know is what he said. I'm not going to guess what was in his mind. I can tell you what he said. And even if he did see that he was going 79, or that was all that is available to him, that's enough. He's going 9 miles an hour over the speed limit. At 79 miles an hour, he is going 15 miles an hour faster than Anselini. If Laura Jones is going between 60 and 65 and he is going 79, that is significantly faster as well, almost 20 miles an hour faster. So you can infer from her perception that it would appear that the defendant is flying by her if she is going that fast and he is going that fast. So it's not all he had to go by was that this speedometer would have said 79. Even if it is, that's not what he saw, because he said. Now, Mr. Drozdowski, the mechanical inspector from Introtech, I don't recall how the testimony that the defendant, or that Mr. Drozdowski said that the steering was tight. I recall Mr. Drozdowski testifying that he saw no defects in the steering. I recall Mr. Drozdowski testifying that when he moved those front wheels, that there was no play in them to indicate that there was a problem. But that is different than saying that the steering was tight, or very tight, like Mr. Matthews says. He said that there were no defects in the steering. So any argument that Mr. Matthews made that is premised on that there was testimony about an overly tight steering mechanism in this car has to consider that. Now, Mr. Matthews mentioned this tire pressure gauge light coming on, and Your Honor, the defendant does tell the troopers that on scene, and it's in his written statement as well. There's been some testimony presented here today about the effects that a low inflated tire would have on the vehicle. But if you're in an unfamiliar vehicle and the tire pressure light comes on, that's another indicator that you should take it easy. Shouldn't speed, shouldn't be trying to switch lanes. Should take it easy. Shouldn't be going 79 or 83, maybe even 70. Failing to avoid a risk. Should have known. You take it easy. Now, the loss of control Mr. Matthews was talking about, the eyewitnesses saw the driving. He oversteered. He says it. It's consistent with the marks. And you consider the testimony of Laura Jones. The defendant, when he proceeds past her at a high rate of speed, and what she thought was this imminent crash that he was going to hit the back of this car in front of him, he was going straight. There wasn't any steering going on at that point. So any steering that the defendant had to do in that moment, when what from her perception was an imminent collision with the car in front of him, was occasioned by the fact that he was driving in a manner that was unreasonable for the conditions. This relates to that speed, where we're talking about reasonable speed given the circumstances. He's driving. She says, oh my God, he's going to hit that car. She slows down and moves to the right. Then the steering happens. And this is after he had weaved and had passed his cars to get to that point, Your Honor. So there is evidence that he is driving in a manner that is unreasonable and at a speed that is unreasonable for the conditions as it relates to that second count of speed. The purchase of the car, it's as is. They told him over and over again, they had him sign 2 forms, Your Honor. You see them in the state's exhibits. One, it's a standard as is, and then they even do a second form that says, we're just telling you again, and we have you sign it. You realize this is yours. He made that choice to buy that car. By the way, the mechanical inspection, the result of that was that there were no mechanical defects in this car. We had a forensic examination of the condition of the car, and he said the overall condition of the car is pretty good, actually, he said. Despite it looking like a rust bucket, it was actually pretty good. It was attractive. You can get a truck for $3,000 out the door. That's attractive to a guy who needs a truck for a job, but it's still a choice that he made. And if there was some idea in his head that this looks a little bit too good to be true, if that's being argued here, then that's even more reason that you take it easy on the way home. You don't put the pedal to the metal like he did when he test drove it. You take it easy. This relates to the negligence. That's the point that he lost control in that imminent crash. He's going straight. He's because of the way he was driving, he lost control. Then he oversteered it, and then the sequence of events happened. He failed to avoid the risk that he's going to hit that car. He didn't perceive it, and then he did, and he hit the brakes. That's negligence at that speed. By the way, the defendant, I don't recall from the recording that the defendant ever said when he hit the gas. He said in the recording, when he hit the gas. Mr. Matthews argued that, you could maybe say that he hit the gas and trying to get it under control in the eastbound lanes. I didn't get that from the video. It wasn't clear to me where he hit the gas. It was my more impression that he if he hit it anywhere, it would be on the grassy median, which, by the way, is consistent with the ruts and the furrows. If you recall, Your Honor, Mr. Cronin testified in those photographs of the tire marks that we had some ruts indicating rolling, rotating of the tires, and then we had the furrows indicating a sliding motion. That would be consistent with that. There's some case law that relates to negligence in a vehicular homicide scenario, Your Honor. Not 11th District, the 12th. State versus Self, S-E-L-F. 112 Ohio Appellate 3rd, 688. It's a 1996 case out of the 12th District, Judge. And at 693, page 693, the 12th District Court talks about negligence in a vehicular homicide situation. And what is the definition of substantial? And they say, at 693, substantial is a synonym of material, which is defined as being of real importance or great consequence. And the 12th District got that from the Webster's Dictionary. They relied on that definition when they made their decision in that case. I think that's probably one of the cases that Mr. Matthews was referring to when he talked about a stop sign. In that case, in this Self case, driver just blows right through a stop sign, hits another car, kills somebody. He should have stopped. He should have seen that stop sign. He didn't. He failed to avoid or perceive a risk that caused this crash. So there are other cases that follow that definition of substantial as it relates to negligence. Speed alone is not enough for recklessness, by the way, Your Honor. But I submit that it is enough for negligence under the circumstances here. Even if you didn't consider all of the other factors which are present. Even if you didn't, if you considered Mr. Matthews' arguments and you looked at just speed in a vacuum, it's enough for negligence. But we have much more than that. We have a person who was in a hurry to buy a truck. He acknowledges it. He says in the back of the video, he says, I shouldn't have even bought this damn truck. Made the decision to buy it, made the decision to drive home. Should have been more careful in an unfamiliar vehicle. Even got a light telling him, be careful. He's not. He's switching lanes. We have an eyewitness who saw it, and he says he was passing cars in the 911, and she said it right here today. So he's got more to go by than some speedometer that he didn't look at. He's got the conditions of the cars around him, and yeah, it was a clear sunny day. So there was nothing obstructing him. He should have been more careful. He's guilty of all these charges, Judge. Thank you.
Thank you. What I'd like to do is, obviously, I need to, review and consider the evidence that was submitted, the exhibits. I'd like to reconvene on Thursday at 10 a.m. for the purpose of announcing the verdict, which schedule would like to have that time.
I can find out real quick.
I'm also turning my phone back on to check, Judge. Thank you.
Hey, am I clear Thursday at 10 o'clock?
Ten, 10:30, I mean, whatever.
Can I ask you to take that off the screen, Judge?
Yep.
Maybe I can access, I don't know if I can
Okay,
access my calendar here. It'd be good.
I have a 10:45 in O'Donnell. That is factoring in the 15 minutes, so if we do, he always wants you to show up 15 minutes early.
10 o'clock should, I mean.
10 o'clock will work?
Yeah.
10 o'clock, if you could put me down for,
Well, hang on.
oh, sorry.
I have a 9:15, sentencing Judge Condon's room, and a 10:45 change of plea. I can make it work.
We're trying to figure out a time.
I can make it work.
Okay. All right, 10 o'clock then on Thursday.
That'll work. Can you put me down 10 o'clock Thursday morning, Judge Culotta? We're gonna conclude this matter.
Should be done by 10.
Yeah, I mean, it's not gonna, I mean, it won't,
All right,
take
thank
long.
you.
This hearing won't take long.
Thank you, Judge.
All right.
If I'm a minute or two late, you know where I am. Thank you.
All right, then we're on recess at this time.
All right.